I'll tell you more or less in general the way I'm going to proceed. I'm going to start out by talking about regulations because, of course, I want to start out on the right foot and talk about something that's really interesting and fascinating to all concerned. Then I'm going to talk about the concept of privacy and go through several legal cases involving the notion of privacy to try to understand how the notion of privacy changes in the law. And then I'm going to be talking about the personal experience of communication, particularly through the internet and social media, and how it affects us personally and socially. And then I will end by trying to identify some of the questions that I think are particularly relevant in trying to think about or sort out both the regulatory considerations and the ethical considerations of research involving the internet and social media. But before I even start that, I'm going to be talking about the internet and social media as if it is a fixed thing. And as this cartoon suggests, even since the invention of the internet has changed dramatically. It was something which we originally thought we could move about in or on anonymously, and now we see it as a way of actually finding people in more efficient and precise ways and getting information about them. And so it's important to recognize that even simply within the time period that we talk about internet and social media, that the thing we're talking about is changing quickly. And to more or less give away the show here, what I'm going to be suggesting overall is that the problem with research in this area has to do with differences in pace. Technology moves at a very rapid pace. The law moves relatively slowly, and human beings move at a glacial pace, even before we thought about global warming. And so the problems that we're facing now, I think, have to do with the fact that those three things changing at different paces create substantial problems for our understanding of how to integrate those things in our lives and research work. We start with the definition of a human subject. Notice that there are two kinds of information that the regulations refer to. One is if you get information through some kind of intervention or interaction with the person. And here the notion of public or private doesn't arise. If the information is obtained through some kind of interaction, the regulations apply to it. Or if even without interacting or intervening with the person, we get identifiable private information. Here's how the regulations explain what an intervention is and what an interaction is. And they're fairly broad notions, sort of anything that you do that changes the circumstances of a person, which you then get information from them about, counts as an intervention or interaction. Here's how the regulations explain public and private information. And the first thing that I would draw your attention to is that, according to the regulations, private information must be individually identifiable in order for obtaining the information to constitute research involving human subjects. Notice that it doesn't necessarily square exactly with our intuitions about what counts as private. Reference was made to those white cards that you can write questions for us and turn in. Well, what if someone instead, what if Camille had said, I'd like to do a little research study, and I'd like you to instead take that card, and I'd like you to write something about how you feel about yourself as a person, and hand it in to me, but don't put your name on it. Now, I think we would say that, yeah, that's private information that you would disclose if you wrote about that and gave it to Camille to do a research study on in order to understand people involved in human subjects protections and their self-images. However, from a regulatory standpoint, it's not private information, because since it's not individually identifiable, Camille would not need to run that research study through an institutional review board in order to do that study. The regulations would not apply to that analysis of that information, which to us ordinarily seems private, but under the regulations is not private information. Here are some other references to public and private in the regulations. And the thing to be aware of, as I'm sure you probably know, is that public and private information are treated separately or differently. If something is public, we more or less assume that whatever risk that information poses is already out there and the person is vulnerable to it, and so there's really no way of protecting them in any significant way in the research use of that information. Whereas private information is something that we do want to protect. There is an approval requirement that refers to privacy. And here I think the regulation, the regulatory language is fairly dense and may well glide over an important distinction. The notion information, private information under the regulations, is protected because it is sensitive. And from a regulatory standpoint, it perhaps doesn't matter whether it is information that only the individual themselves has, or whether it is information that the person has shared with someone else under some kind of confidentiality safeguard. But realize that privacy and confidentiality are distinct things, that privacy is the notion that nobody gets access to the information. I can keep it to myself, whereas confidentiality has to do with the disclosure of the information to some other person for a specific purpose on condition that they won't redisclose it to someone else. We cherish privacy. We think it's a good thing to be able to have. At the same time, there are other things that we cherish that are interested in moving into the area of privacy in order to pursue other endeavors which we also regard to have some kind of social worth. Science has important questions to ask about our private behavior in order to try to understand private behavior and in order to figure out ways to improve people's private lives. The same thing with these other things on the list. These are things that we endorse and want to give rein to. At the same time, we have to recognize that they may move into the area of privacy and threaten it in various ways. When we look at privacy, trying to understand it, I think it poses a number of challenges. The first is that what privacy means varies from culture to culture. Second, privacy, as I said about the internet, privacy is also something which changes over time. Our understanding of privacy is not the same as the understanding of privacy of 100 years ago or a couple of hundred years ago, as I'm going to try and illustrate. Privacy is a right, not an obligation. And so you can give up your privacy if you so choose, right? I had a colonoscopy this spring. Now, until I said it, it was private information, right? It's a lot of fun. But I haven't done anything wrong by disclosing that information, and it is now public. I'm not obliged to not tell anybody that I had this, right? I can if I choose not, right? And what people choose to keep private and when they're willing to not exercise the right to privacy can be quite surprising. Not that any of you use it, but just show of hands, does anybody know what OkCupid is? Okay, for those of you who don't know, it's an online service that enables people to date. You fill out a questionnaire about yourself, and OkCupid gives you names and contacts for people that they think might be compatible with you. Now, in that questionnaire, one of the background questions that women answer is, have you had an abortion? And you can check the box for whether you have or not, because OkCupid thinks that this information will help them in deciding who you might be interested in or who you might not be interested in. But after that box, there's another box that says, keep this information private. So you can tell OkCupid whether you don't want them to tell anybody else what you just said, what you just told them, or you can leave the box blank and allow OkCupid to disclose that information about you to someone else. Of the women who say yes, that they had an abortion, less than 50% of them check the box saying keep this information private. On the other hand, in another survey of private information, when people were asked if they would be willing to share their credit card purchases and social media activity with their health care providers so that the health care providers would have more information about them to counsel them about behavior and trying to stay healthy, 70% of people less than 35 said, no, I don't want my health care provider to have that information. And 80% of people between 35 and 64 said, no, don't tell my doctor what I've been buying and what I've been saying on Twitter. Even if it will help my doctor tell me things that I should or shouldn't be thinking about doing. As I'm going to say, I think privacy is shaped by technology. And because of the ways in which technology shapes privacy, I'm going to suggest that the boundaries of privacy are becoming easier and easier to cross. So first, this notion of cultural variation. here are in our society, here are four legally recognized relationships of confidentiality, so that in a court of law, you can assert that the information is confidential and be able not to disclose it, right? But notice that all four of these circumstances of confidentiality are culturally bounded. Starting from the bottom, that notion of confidentiality is meaningless if you don't have a religion that includes the practice of confession of sins. You have to have a legal system in order to have an attorney-client privilege. You have to have the practice of medicine in order to have the physician-patient relationship. We may say that marriage is something universal for all societies, but while that may be true, we of course have seen in the last 10 or 15 years a huge change in our society in the institution of marriage and who counts as a spouse. So let's go back to the 11th century and a famous, I think, illustration of the notion of privacy. This is a story that comes from the 13th century about a noblewoman, Lady Godiva, the wife of the Earl of Coventry, who was upset about how much taxes the Earl was imposing on the people of Coventry. And she complained to him about it. And at a certain point, he said, okay, I'll decrease the taxes of the people of Coventry if you will ride naked through the town. Lady Godiva let it be known that on a specific day, at a specific time, she would be riding naked through the town of Coventry, and that she would appreciate it if she wasn't seen. And because they also understood why she was doing it, all of the people of Coventry went into their houses and shut their doors and windows and didn't watch. So this is, I think, an interesting and intriguing example of what is arguably private behavior in a public place. Move on to the 18th century, and this story of Lady Godiva adds another dimension. One man, so the myth goes, wanted to see Lady Godiva and drilled a hole through his shutter so that he could watch her with his shutters closed. As according to the myth, there are two different versions. One is that when the townspeople of Coventry found out about this, they blinded him. The other version of the myth is that God struck him blind for invading Lady Godiva's privacy. Fast forward to the 18th century, and here is one of the provisions in the Constitution, which is the one I'm going to be talking about for the next little while, which is used to make the claim that there is a right to privacy in the American Constitution. Notice that while this talks about being secure in your person, houses, papers, and effects against searches and seizures, the Fourth Amendment does not actually use the word privacy, nor does the word privacy exist anywhere in the U.S. Constitution. But the Fourth Amendment is the locus of a considerable number of legal cases in which the concept of privacy and what it applies to is the subject of some legal decisions. So let's talk about the first one, which is Olmstead versus the United States. It's a case that involves bootlegging during the period of Prohibition when alcohol was illegal in the United States. And there was a fairly elaborate operation on the West Coast for moving liquor from Canada to Washington, and from there to various places where people would be able to get alcohol. They moved supposedly about 500 cases of liquor a day. And they were discovered through the use of wiretaps, where the government put taps on the telephone wires in between the various houses and the office building, where the bootlegging operations coordinated the movement of the various ships and the transportation of the liquor once it came from the ships onto land and moved to the various distribution points. And the argument, the question was, did they invade the privacy of the bootleggers? And Justice Brandeis, in the dissent, argued that they did. And this is perhaps the first place where there is a clear statement in a Supreme Court decision of the notion of a right to privacy. But realize Brandeis, right, who thought that people have a right in their own homes or in their private places to be left alone, right? He was in the dissent. The court found that this was not an invasion of privacy. Why? Because they didn't go into the houses or the office building of the bootleggers. They were able to tap the telephone wires in between these people and listen to the conversations that way. And so because the telephone lines were out in public, the argument was that there was no violation of privacy. 1967, now we have a case about bookmaking, gambling. And the bookmaker in this particular case, Katz, used telephone booths to make calls to various people who wanted to place bets. And the police put a listening device on the outside of the telephone booth and recorded Katz's conversations and used it as evidence in the cases. This time, the court found in favor of Katz and said that the use of the listening device without a warrant was an invasion of privacy. Why? Because they said that Katz had a reasonable expectation of privacy. He went into the telephone booth and closed the door and presumed that no one was overhearing the conversation he was having with the people who wanted to place his bets. And so the government had intruded upon his privacy. And so that evidence was thrown out. There was a dissent that was consistent with the majority position in the Olmstead case. There was a justice who said, didn't go in the telephone booth, right? Stayed on, the device was on the outside, and so since they didn't go inside the telephone booth, this was not a search and it was not an invasion of privacy. 1979, a woman in Baltimore named McDonough gets robbed. And she starts getting harassing calls after the robbery from the guy who claims that he took the money from her. And she had noticed, she had gone outside after the robbery, and she had seen a 1975 Monte Carlo parked across the street after the robbery had taken place, and had noticed it. She, at one point, this caller calls her up and tells her to go stand outside. And sure enough, drives by in that 1975 Monte Carlo. She tells the police about this. The police find the Monte Carlo, use the license plate to identify who the guy is who owns the Monte Carlo, and goes to the telephone company and says, will you please use this gizmo that's on the slide, which is called a pen register, originally used to record the electromagnetic impulses in a telegraph, but also a technology which can be adopted to a telephone, to identify the telephone numbers that the owner of the Monte Carlo is calling to try and establish that he is indeed the guy who committed the robbery and is now harassing McDonough. They use the pen register, and sure enough, this guy is making all these calls to McDonough's phone. They use this evidence in court. Smith, the Monte Carlo owner, says it's an invasion of my privacy. Who I called on my telephone is something that is not public information. The phone company shouldn't have turned that information over to the government. In this case, the government wins. And the majority decision is that Smith had willingly given to the telephone company the numbers that he wanted to call, and so he had disclosed the information to a third party, which was entitled to then turn that information over to the government. Particularly since part of the argument had to do with the notion that all that was being turned over was the numbers that were being called, not the actual content of the conversations. However, there was a dissent, and the dissent was that this was something that Smith should have been able to assume the telephone company was only going to be used for its own internal purposes of billing and monitoring telephone usage, and that he should not have been able, have had, to think about whether the telephone company would repurpose this information for other reasons. And in this decision particularly, there is a recognition that, combined with the case before, that there is now a two-part test for the notion of privacy, which is, first of all, that the person had a reasonable expectation that the information would be kept private, and secondly, that society is prepared to recognize that the expectation is objectively reasonable. And what the court found in this particular case is that the second standard wasn't met, that society wasn't prepared to honor his assertion that the information that he gave to the telephone company shouldn't be repurposed for another interest which actually was opposed to his. Last case, 2012, now we're talking cocaine. Cocaine smuggling or trafficking operation in the District of Columbia. The police put a GPS device on Jones's wife's Jeep Cherokee in order to track its movements and eventually establish that that car was indeed regularly parked outside of the stash house where they found $850,000 in cash and a couple of hundred pounds of cocaine. Used this information to include Jones in the arrest, and Jones said, you shouldn't be able to use the information from the GPS because it's an invasion of my privacy. Scalia writes the majority opinion. He says, yeah, it's a search of the car. Even if we use the Fourth Amendment language, and even if we look at this in terms of interpreting the Constitution from the standpoint of how the Founding Fathers understood the Constitution, this is an effect of which there was a search, violation of the Fourth Amendment. The evidence is out. But if you look at the decisions of Alito and Sotomayor, who concurred with Scalia's conclusion, they raise more subtle and different concerns having to do with the two-part test that I just talked about. They say, while it is clearly a search in this instance, it raises the question of whether we need to think more carefully about under what circumstances, when information gets disclosed to third parties, what our expectations should be about whether that information remains confidential in some sense and can't be disclosed for whatever purpose the third party feels like disclosing it. So again, to emphasize the right to privacy, it's important to see both sides of the stop sign. You both have to have someone on the inside saying, stop, I don't want you to come in here, the reasonable expectation of privacy. And secondly, you have to have someone on the outside who honors the stop sign and says, if you say stop, we have agreed that under these circumstances, I'm supposed to stop and not try to cross that chain. We don't always ourselves rely properly on when that expectation is going to be honored or not. For those of you who have never been in the men's bathroom of the Montreal Convention Center, this is a photograph of that particular venue. You see that little tiny glimmery thing on the wall at the far end? That's what it says. For whatever purpose it may be, that somewhere where we want to carry out some activity where our instincts, if you will, tell us, now we're doing something private and nobody should be looking at me doing what I'm doing, right? We have these social interests where we override that expectation and say there is a purpose that we have for which we want to watch you. And this is a fairly pervasive thing in our society and is growing. So now I'm going to talk about our personal experiences of privacy, but I want to begin with a point from a different area of human life, with an idea that originally comes from a 20th century German philosopher by the name of Hannah Arendt, who wrote about violence and the impact of technology about violence. And the point that she made in sum is that technology changes the experience and the significance of violence in very fundamental ways that lead us to not be able to rely on our unaided senses to appreciate the consequences of what we're doing. It takes serious effort to kill somebody with your bare hands. And while you're doing it, you're going to be conscious of what it is that you're doing in a very immediate and visceral way. Once you invent a gun, which you can, forgive the expression, point and click, you accomplish the same aim, objective, but in a way that your physical senses doesn't immediately give you the same kind of feedback about. Because with very little effort, you can kill somebody at an extreme distance, almost effortlessly. And she uses this notion both to talk about technologies involving weapons and automated weapons, but also to talk about nuclear war, and the notion that technology has so dramatically changed the way in which we commit violence that we no longer can rely on our immediate physical senses to appreciate what it is that we do when we do it. And I want to suggest in a parallel way, this is also true of communication. We used to write letters, and the letter would only go to one person, and the person would have to physically hand it over to somebody else if they wanted to disclose that information to someone. Then we developed the telephone, which made it much easier to have communications with individuals at a distance. But it was still from a fixed location, and generally the number of parties to those telephone conversations was quite limited. Now we have cell phones which we can carry with us everywhere, and those cell phones enable us to communicate by conversation on the cell phone and by texting in ways that can be rapidly multiplied by forwarding those communications to other people. Let me go back to the telephone booth. I don't know if you know this story of the little boy and his father who are walking down the street. And the little boy sees the telephone booth and says, "Dad, what's that?" And the father says, "That's a telephone booth. You can go in there and there's a telephone and you can put money in it and you can use it to call anybody you like." And the kid says, "Hey, way cool. You know, if they build enough of those, we won't have to carry cell phones anymore." Now, the thing that we generally concentrate on in looking at this story and in thinking about the difference between using old-fashioned telephones and cell phones is that we can carry the device around with us, and it makes life more convenient, and we can call from wherever we want. But the other thing that we have to notice here is that we've lost the booth. And so now, unlike what happened when we still had the old telephones, when you get on an airplane, before it takes off, before everybody says, "Love you, honey, I'll call you when we land," we all overhear what we take to be private conversations all around us. And we presume, if you will, that other people won't listen to our conversations, but we're perfectly able to now because we no longer have that physical barrier to keep that conversation private. So it's the case that we're having these private conversations, right? But the ability of other people to intrude upon our privacy is ubiquitous. In addition to that way in which our world is being changed by technology, there are others. I mentioned OkCupid. It used to be that if you wanted to try to meet somebody to develop some kind of relationship, you went to a bar, you ordered a drink, you had face-to-face conversations with people, and you tried to sort things out. Now you get matched up with someone online. If you had some kind of psychological problem, years ago, you would lie on a couch and you would talk about whatever came to mind, and someone would sit and listen and try to sort this out. Now what happens is you get put in an MRI machine, and there's this notion that if we look at where your brain activity is occurring, we can sort out what's wrong with you and how to fix it, but in a way which short-circuits any awareness by the person themselves of what it is that's being observed. Show of hands, how many people here recognize these four white guys? Okay, now do you recognize these four white guys? They are the leaders of these four organizations, and they're very interested in research. They are collecting a huge amount of information which you hand over to them, which they use for their own research purposes, and which they turn over to other people who are interested in that information. Bezos's business model is not designed to sell books. Selling books is his excuse for getting information about people who buy books from him, which he can then turn around and make available to other vendors who want to sell you other things depending on the content of the information you give them, him, and the purchases that you make. So these four operations and many others are raising the question of, can they use this information to carry out research of their own? Can they turn around and turn that information over to somebody else? Of course, they told you the conditions under which they could turn that information to somebody else. On page 15 of that Terms of Agreement document, which you didn't read before you clicked I accept, right? Which was smart on your behalf, of you not to read. First of all, because it's written in language you can't understand. And second of all, because the opportunity costs of the wasted time that you would need to invest in order to read all of those agreements before you accept the various transactions you agree to is in the billions and billions of dollars within the United States. But that's where the action is in terms of the set out model of the circumstances in which those disclosures will or will not occur. And of course, since they're not getting HHS funding, they can do research with that identifiable data that you turn over to them, which is or isn't private, without IRB review of any sort whatsoever. It's so easy to move information to hundreds of people through the various kinds of mechanisms of cell phones and the other apps that they make available to us. When I sign on to my computer at work, I get this screen. And the reason why I get this screen, I presume, is because there are plenty of people who do have an expectation of privacy when they send emails. If you send me an email, and not only do you want to ask me a regulatory question, but you also want to disclose some kind of information about yourself, that information is FOIable. You know, it can be swept up in a request for information. It is public information. So don't just think that you're communicating with me when you send me an email. Everybody's familiar with these various texting terms that people use, like TMI and LOL. I've invented my own because I'm trying to be technologically with it and failing. Here it is. It's called Nope. Because I think that if you want to preserve your privacy in some circumstances, you don't send it by email, you call the person on the phone, or you walk down the hallway to have that conversation, because it is then not recorded and easily disclosed to a third party. Same thing with pictures. I've never been on Instagram or whatever, but remember when we used to have to develop film and decide how many copies of the picture we wanted printed for how many people we were going to give it to, right? That world is gone. And it's much easier on the investigator side to get that information. You don't have to go through dusty boxes and look at paper anymore. You can go to the cloud and use algorithms to mine millions and millions of pieces of information quite efficiently. This is a quote from Christian Rudder, the guy who runs OkCupid, about the data that he makes use of and the fact that the information is so much more available to researchers because it's recorded in a permanent or semi-permanent way, particularly given the fact that now we have this thing called the Wayback Machine that takes periodic snapshots of everything that's on the internet. So even if you take it down, the Wayback Machine still has it. This is a famous quote that to the effect that our world has moved to a point where privacy doesn't exist anymore. I think the other thing that is important to keep in mind is advances in psychology, which enable us to have a much better appreciation of the ways in which decision-making is patterned and the ways in which we can influence decisions without people's being aware of it. Here are some notorious internet studies. Facebook, how many of you know the Facebook study? I've heard of the Facebook, most of you. Influencing positive and negative messages to your feed to try and influence your emotional state. OkCupid deliberately mismatched dates to see whether mismatching people actually led to poorer dates. And a couple of people at Columbia and Penn sent out phony requests to graduate faculty asking for an appointment either almost immediately or a week from now to find out about the graduate program, to test to see whether the faculty would behave differently depending on whether the request was an immediate one or one a week away. And they included as a variable names from the requester that clearly indicated the gender or race ethnicity of the requester. And interestingly enough, while we may presume that the academic world is largely populated by relatively liberal people who claim not to be racially biased, they found a significant effect both in terms of turning down the requests by minority members more and turning down the requests by women more frequently when the requests were a week away. The academic community got all bent out of shape about this initially and went on the blogs and complained about being deceived in research, etc. It was especially interesting when they found out the data were being used to analyze these differences by race and ethnicity. I think that the clamor subsided because the academic community decided that this was actually a piece of research that was worth doing, and so they were less offended. Yeah. So I'm going to need to move pretty quickly through the last couple of slides. I want to go back to Hannah Arendt, who actually went back to Aristotle to talk about our notions of public and private, and to say that in 5th century Greece, there was this distinction between private, which happened in the Greek household, and public, which happened in the theater, the political venues, and the agora, and to say that there are some things that really need to be hidden in order for them to exist, for us to have our private lives, that we're not being observed. And yet there are other things in the human world that can only exist when they are things that are out there for other people to see. Political interaction, for example, is a fairly an activity that we seem to be paying a lot of attention to lately. You can only engage in political dialogue in public, where others can hear you. And what Arendt argues is that over the last more than 2,000 years, there's a third thing which has emerged, which isn't purely public and isn't purely private, which she calls society, which is taking the activities which used to be in the household and having them be carried out in public, and that this creates challenges to us about how to view those things. Oh, no, I don't want to show you that. And what I'd like to suggest here is that there is a kind of activity which we don't consider public, but we also don't consider private. And remember, when I was talking about the regulations only refers to public things and private things. So what do we do with information which is obtained in a context which is neither public nor private? Take, for example, a classroom. Access is limited, right? We don't consider a classroom to be a fully public space, but we don't consider it to be private either. What happens when your unit at your institution has a meeting and discusses something and talks about how things are going? It's not a public meeting, right? But it's not a private meeting either. And notice that for these kinds of activities, shopping online, shopping in a mall also, and then now carry this over for the internet and social media to things like chat rooms and online shopping. The issue which arises is that issue that I was talking about in those legal cases, which is there a reasonable expectation of privacy? When you say something at a meeting, or the teacher says something in a classroom, is there the expectation that that information won't be redisclosed? And I think the answer to that is no, right? A lot of those things are said in those meetings, which are limited access, but for which there is the expectation that people are free to redisclose that information to other people for whom it is important, and there's no violation of anybody's rights by doing that. So this is a cartoon meant to sort of indicate this sort of odd thing where we have one feeling that we are ourselves isolated, and yet we recognize that our communications are quite widespread. And this is my final slides. So here are the things that I would suggest one wants to think about in looking at a research study here. The first is, will the subjects provide informed consent? For a research study on the internet or through social media, a lot of the problems go away if you have the person's informed consent, because then they make the decision about whether they're going to exercise their right to privacy or not. Does the research involve intervention or interaction with the subjects? In all three of those interventional studies, all three of those notorious studies I mentioned, there was some kind of intervention or interaction. And that's what got the people upset about having something done to them without their being aware that something was being done to them, and were offended by it. Whether the information that's obtained will be individually identifiable, back to that thing I was talking about earlier about putting things on the cards. Yep. Whether it will be kept confidential, and then particularly, do the subjects in this particular activity, do they expect that their information could be redisclosed or repurposed? Because that, I think, is crucial to the decision or judgment about whether you're talking about private information or not. And for that, you have to look at the specific social context in which the information arises. And then finally, there's the question of whether you simply ought not to go there. Do you really have a sufficiently legitimate reason to carry out a research study on something which is ostensibly private behavior? Or is it the case that the appropriate thing is to simply turn away? I'm a little bit over time, so I'm thinking we need to go straight to the break. I think people's attention and other things have reached their limits. So I will be around, and of course, if you have a question about the talk that you want to put in the Ask the Fed section, I would be happy to respond then. Thanks for your attention.